On March 10th, 2020, Peter Nicholas published an article in The Atlantic entitled, "There Are No Libertarians in an Epidemic." That phrase morphed into a question all over Twitter, all over libertarian podcasts. Are there really no libertarians in a pandemic? And it was a question that rung true to a lot of libertarians and probably a lot of conservatives. People who would usually oppose state overreach, mandatory lockdowns, were much more silent than you normally would have expected them to be. People were really and truly worried about the coronavirus, and really and truly worried that mandating things be locked down, at least temporarily, was the only way to stop it. And libertarians felt like, well, if we support this, are we abandoning our principles? And did a good deal of soul-searching. Now, whether you think, in hindsight, those lockdowns were justified or not, is not the question I'm asking here. But we can clearly imagine a situation where they would be, where lots and lots of people would die unless we, with the power of law behind it, forced people to not interact, or not interact as much. And the question is, in my mind, are there libertarians in a pandemic? Would a truly libertarian legal system and a libertarian society have the tools at its disposal from just a purely legal precedent philosophical perspective? If we're going with a libertarian legal philosophy, could a libertarian society put in place the kind of policies they would need to weather this? And would it be consistent with libertarian principles? And so the point of this video is to sort of outline a way in which you may be able to justify something like this if it was truly needed and necessary. And of course, if there are invisible hand sorts of mechanisms where people's voluntary actions will result in the same outcomes, legally mandating them may be overkill. But I just want to present a possible viable case for why a libertarian legal philosophy could justify certain mandates in a time like this. Now, this video ended up being way too long, and this new introduction I'm shooting is also going much longer than I hoped it would. So this video is going to be broken up into at least 2 parts, maybe 3. Now, this first part is going to be almost entirely irrelevant to the question at hand. It's going to be laying a lot of groundwork. I'm going to be talking about Robert Nozick's Anarchy, State, and Utopia, and why I like it so much and think it's a great book. And then I'm going to be talking about, for the lion's share of the video, why Nozick thinks a libertarian legal system should adopt a retributive theory of justice and should prohibit certain actions. So that has nothing to do, and by certain actions that violate rights, and he means something very specific by prohibit. We'll get into it in the video. That has almost nothing to do with the coronavirus. So if you start watching this video and it has nothing to do with coronavirus, you're not insane. It's tertiarily related. It's laying groundwork for a further philosophical argument that Nozick also makes. And so that's going to be part 2 of this video, which is going to be about risk. So the reason this discussion we're going to have about retributive theories of justice and allowing prohibition is necessary is it lays the groundwork for arguing that a libertarian society can, at least in some cases, prohibit people from doing things that have a risk of violating other people's rights, but don't have a 100% certain chance of violating those rights, and gives us sort of a framework for thinking about when and when it isn't okay to prohibit people from doing risky things that have a chance of violating rights. Okay. If there is a third part of this video, which I haven't decided on yet or not, it's going to be me talking about why Nozick's argument doesn't actually neatly apply to the sort of situation we're in right now. It may apply in some unique individual circumstances and cases, but I think largely this sort of case is a failure. But I do think that a libertarian legal framework would likely have the robustness and wherewithal to deal with real emergencies where a invisible hand mechanism sort of solution isn't forthcoming. And I think in this particular case it probably would have been more forthcoming. And anyway, we'll get into that in the third video, if and when that gets made. But there's definitely going to be at least two. So, part 1, Groundwork, random, talking about retributive theories of justice and prohibition. Part 2, coming out later, will be talking about risky behaviors and what a libertarian legal framework would say about them. I'm hoping today to address the question, what would a libertarian legal system do about people's behaviors and actions that have a chance of violating someone's rights, but don't necessarily violate their rights? And is it possible for the world to change, or a situation or circumstance to be such that something that used to not have a significant chance of violating rights to now, under the new regime, actually have a chance of violating rights? Okay. Now to the long, circuitous part of this. We're going to look at this through the lens of Robert Nozick's Anarchy, State, and Utopia, specifically Chapter 4, which is his chapter on prohibition, compensation, and risk, where he addresses this very question. However, before we jump into that chapter specifically, I want to give you all some context on what Nozick is doing with Anarchy, State, and Utopia. His book is broken down into 3 sections, the 3 parts of the title: Anarchy, State, Utopia. Part 1 on Anarchy, he is dealing heavily with our other libertarian big boy, Murray Rothbard. He finds Rothbard's ideas very clearly to be very convincing. He's a libertarian, and I don't think he's as far away from Rothbard as a lot of people would say he is. But the first part of the book is designed to give him an out so that he doesn't have to be an anarchist, essentially. He starts in part 1 with a libertarian legal framework that is very, very close to Rothbard's. He doesn't depart from it particularly often at all, and then attempts to show how, under such a framework, a minimal state could be justified. That's part 1 of the book, Anarchy. Part 2 of the book, State, he tries to show that going any further beyond a minimal state is unjustified. In this part of the book, in the same way that part 1 of the book was very clearly responding to Rothbard, footnotes Rothbard tons and tons of times, talks about him constantly. The second part of the book is very clearly targeted at Rawls and Rawlsianism. He wants to show that Rawls is justification for a state that does redistribution of wealth and distributive justice fails. But more generally, he just wants to show, though, that any state that's larger than the very minimal state he outlined in part 1 is unjust. And I think he does that fairly successfully. The final part of the book, Utopia, he tries to come at it from a different angle. Like, part 1 of the book was showing minimal state justified. Part 2 of the book showing anything larger than a minimal state unjustified. Part 3 of the book, Utopia, is only 1 chapter and it's short. And he tries to go through a series of different arguments showing that his minimal state world is a good world to live in, and a world that is a good approximator of what a utopia would be. He's kind of tongue-in-cheek about it, and part of the reason he talks about utopia is because he presents a thought experiment that's kind of weirdly similar to Rawls's veil of ignorance, but different. He's still kind of thinking about Rawls in this part, but then showing how that from that he can spin out a libertarian minarchist society. All right, one more caveat. I think that I am convinced that anarcho-capitalism is most likely true. I think that it is the case that taxation is immoral and theft, and that it expropriates things from people that they have a right to. I also think that it is probably true that you could have a society that works in an anarcho-capitalist fashion and still have robust laws, still have high quality of living, and not have... Like, I basically buy Rothbardian-style anarcho-capitalism. However, that being said, I think Nozick makes a very, very interesting argument that goes far beyond the standard, well, in an anarchist society, eventually a state is going to arise because one of the multiple competing law enforcement agencies is going to set itself up as a monopoly and kick everybody else out. A lot of people say that's what Nozick is arguing. It isn't. It's part of it, it's a small part of it, and an unconvincing part of it, but his overall argument is much, much better than that. And I think there's a problem in modern libertarianism with too many people being anarcho-capitalists, even though I am one myself. I think it's probably correct and true. I think in order for our movement to succeed, we need to have fewer of those people because those people just sound radical and extremist. And so in order to have a healthy movement, what we need to have is we need to have your reasoned Cato-type libertarians who aren't... They're more utilitarian, they're more pragmatic, they're for something close to a minimum of government, but they're maybe willing to make a couple of exceptions for a school voucher program, or, you know, maybe funding roads, maybe not. This, that, or the other thing, where they say, okay, fine, we're willing to carve out this little extra part for a state beyond the minimal. I think those people are a healthy part of the movement, and that we need them to be taken seriously, and that we need their policies to be put in place to move us closer to the sort of a world where we can actually have a libertarian world. However, we also need principled libertarians who aren't just making utilitarian arguments, who have sort of a philosophical libertarianism, but whose philosophical libertarianism is strong enough to get you to minarchy. Right? We need those sorts of libertarians too, which is how I think a lot of libertarians start off. They start off with this idea that the purpose of government is to protect your rights from being violated, and that anything else the government does is unjustified, but that taxation is okay in order to fund enforcing your rights. Then a lot of these people are convinced, the way I was convinced, that using taxation to fund enforcement of rights is itself a violation of a right, and then they have this crisis where they think, well, how can I justify the existence of a state at all if a state necessarily violates people's rights? But there really is no alternative if you want to have people's rights protected at all. And then they hear the Rothbardian, David Friedmanian case for how such a society could function. And then they're convinced and they become anarchists. I think that's unhealthy in the long run. I think we need those anarchists, but I think we also need a robust set of people who don't eventually get pulled away from being minarchists into being anarchists. We need more people who are able to stay minarchists and defend minarchy. And I think Nozick could be really, really helpful for that if people understood his argument. And that's not what today's video is about. I'm not going to defend his argument today. I think I'm going to leave that as a mystery for a later video. And we will get to it when we'll talk about it. But today we're going to talk about a small piece of what his argument is. And maybe you'll be smarter than me, and you'll be able to see where he's going with this. Because when I first read Anarchy, State, and Utopia, is what convinced me to become an anarchist, because I thought to myself, is this really... I was in high school at the time. I had just read The Ethics of Liberty. I had read Market for Freedom by Morris and Linda Tannenhill, and I'd read a couple other things, and I was starting to think, oh, I might be forced to be an anarchist, logically, in order to be consistent, and I did not like that. So I looked online and I found, okay, the most well-respected person who holds the same sort of core libertarian beliefs that I do, who rejects it, is Robert Nozick in his book Anarchy, State, and Utopia. I'm going to get that book and see if he can convince me. And I got it, and I was in high school, and I wasn't equipped to understand what he was saying at the time. And so I struggled and read it, and I got to a point, and I thought his argument was just, well, you'll have a bunch of different protection agencies, one of them will set itself up as a monopoly, and there you have a state again, and that's bad. It wasn't until I reread the book, older, having graduated college, that I understood his real point. Where was I going with this? I got way off track there. A small part of his argument that's very important, that maybe you'll see where he was going. Even as an adult, when I read the book, I didn't see where he was going with it until I got further in. But a core important piece of his argument is that it's okay, not just okay, a correct libertarian legal theory would require that we prohibit certain activities that have a risk of violating other people's rights, even though they may not, in the end, violate people's rights. All right. So now we're just going to walk through it from the beginning, before he even starts talking about risk. So the first thing he asks is, why should we prohibit any rights-violating activity at all? Now, he doesn't mean by prohibit what you or I might initially think prohibit means. It's pretty clear that if you have a right to something, it's wrong for someone else to come in and take that thing from you. Right? That shouldn't be allowed. And if they do that, at the very minimum, a legal system should come and take the thing from them, or some amount of money or monetary equivalent that would be enough to compensate you, make you feel as though you're whole for what was taken from you or for the harm done to you, so that you'll be willing to say after the fact, post the thing happening, that you're as well off as you were before, that you would be willing to say that, or would feel that. That's the minimum duty of the legal system. However, that's not prohibiting in Nozick's schemata. Prohibiting means any penalty enacted on the wrongdoer that is above and beyond that. So let's say someone comes and they steal $100 from you. The police find them. They take the $100 back. Maybe the guy already spent 10 of them, so they take $90 back and 10 extra bucks from the guy, making $100, and they give that money back to you. And that's all they do. They do that. They have a small little trial to demonstrate he did in fact steal it from you, and his rights aren't being violated by the $100 being taken back from him, and they give you your money back. But they don't take anything in addition to the $100 from him. In Nozick's schema, that is not prohibiting the taking of the $100. Prohibiting the taking of $100 would be to say, all right, we're going to take the $100 back, give them to the original guy, but we're also going to impose an additional fee or penalty for that person's violation of your rights. Rothbard is actually also in favor of doing this, of prohibiting things. In the Ethics of Liberty, he thinks you should be prohibited double. You steal $100, $200 should come out of your pocket, be given back to the person who you took from. He's for, I don't want to say double restitution, but he's for complete retribution, if you will. Let's not get off on Rothbard and the Ethics of Liberty. Let's stick with Nozick for now. Okay. So Nozick says, all right, so you have this choice. You can either prohibit everything. You can have an additional penalty on top of everything besides just making restitution when you've committed a crime. That's option one. Option number two, you can prohibit nothing, and anytime anyone commits a crime, they just have to make restitution the person they took from, get that person up to the point where they are happy that it happened to them. That's a bad way to put it, but you give them back enough that they're willing to say, okay, I'm whole now. but you don't go beyond that at all. Or finally, you can prohibit some things and leave other things not prohibited. Okay. So first, let's talk about why some things, at least, need to be prohibited or should be prohibited. So Nozick gives 3 reasons as to why we should prohibit, 3 arguments. His first argument is essentially an argument that without prohibiting anything, with just requiring that the aggressor should return whatever was taken, you don't deter. You don't deter them taking it at all. He starts off by giving the people who say, all right, we should never prohibit, the benefit of the doubt. There may be some deterrence, a little bit of credit. He says, all right, in addition to just returning whatever they took, they are probably also going to be required to give any compensation above and beyond what was taken. So let's say they stole your car and that kept you from getting to work for a couple days, and let's say your boss was fine with it, you didn't lose your job, but you didn't get paid for those days because you didn't have any hours. Well, in that case, they would be required to pay you the money for the days of work you missed. Or if they just stole $2,000 from your bank account, they'd be required to reimburse you the interest of what they took as well. So just full compensation for damages. If they caused you emotional distress, there might be compensation for that. So they might have to pay you more than just the monetary value of what they took. If they stole a bauble, sold it for $600, and the bauble had sentimental value to you, they'll have to pay you above the $600. And that might deter people a little bit, because that'll add on to things. There are also emotional costs to being arrested and being dragged in front of a court and having to miss days of work because you had to go and defend yourself and present a defense. And there are costs of paying for a lawyer, even in like an ideal society where maybe such things are much less expensive or what have you. There's still additional costs there in terms of just the costs to that person. The main ones being emotional sorts of things about having to defend yourself and being labeled by society and your neighbors as a thief or a rapist or whatever it is you've been accused of doing. So there are the emotional costs that might pose a cost to the person, might go towards deterring them. And finally, the overhead of running the court, sending the police to catch the person, doing the detective work, the prosecutor, if the person can't hire a defense attorney, and they have to be provided one by the court, those are all also things that the captured person would probably have to do. So with those 3 additional costs combined, beyond simply the cost of whatever you took, like let's say you steal a $700 vase from someone, if you were only required to return $700, there would literally be no incentive for you not stealing the vase, because if you don't get caught, you're ahead $700. If you do get caught, and you just have to return $700, you're no worse off. However, if you combine the other costs in, which he labels each of them with figures, with the C for the compensation above and beyond, as I called it, D for the emotional cost of being tried and the time taken away from your life, and E, the cost of being caught. With all those things added on to the $700, that like all 3 of those things might help to deter you. However, what are the chances of you actually being caught? Let's assume we have a great legal system, and there's a 10% chance of actually catching you, of actually you being found out. Maybe that's low. I don't think it's low. I think that would be a pretty decent legal system. I don't know. I should probably look these numbers up before talking out my arse, but I'm doing it anyway. That seems pretty reasonable to me. Like there's a very good legal system having a 10% chance of catching you, the right guy, and bringing you to trial. So, let's say you're a completely rational person. You steal the vase, 100% chance of you getting $700. 10% chance of you having to pay back, let's say all those costs add up to $1,000. say how that's how much the court is going to charge you and everything for catching you if they happen to catch you on video camera or something like that. You multiply that by 10%, that's still a lot less than the $700 you'd be ahead, right? So let's say they're going to charge you $1,000 for everything. Well, 10% of that, 10% chance you get caught is only $100. Even if they would charge you straight up double, so that you have to pay back $1,400, and that extra $700 would be the, extra compensation for the person, your personal internal valuation of the time lost and whatever, and the cost of running the overhead for the court or whatever. Combine all three of those together, 1,400 times 10%, $140. Still not really going to deter you that well from doing it. So he says, all right, so just C plus D plus E, unless you have a really high probability of being caught, is probably not going to be enough to be a deterrent to someone willing to commit a crime and violate rights. So he lines out a couple alternatives, alternative legal systems or theories under which we could operate that would have a greater deterrent. So first, you could have people who are retributionists. So, like Rothbard in The Ethics of Liberty, where the person stole a $700 vase, so they were willing to inconvenience you to that extent, so they have therefore given up their rights, and it is just to inconvenience them to the same extent. So that would be sort of the retributionist theory, and that would put an upper cap on how much a person should be, should be charged above and beyond simply making restitution. So you still have this the C, D, and E, the interest that they have to make back, the emotional damages, the time you missed work because your car was stolen, whatever. They still have the emotional costs, they still have the costs of the overhead, but now, on top of all those three, you also have the harm that they inflicted on someone else, being an additional charge that is appropriate to inflict upon them, that would go towards deterring crimes in the future, right? And so this would be an example of, like we said before, prohibiting a particular crime. If you say, in addition to making restitution, you're also going to be liable to have the same amount of damage done to you and your finances and your belongings if you commit this crime, that sort of retribution is a form of prohibition. However, like I said before with the $700 example, and Nozick recognizes this completely, when P, the probability of you being caught, is small, or when the degree of harm you did is small, and so the amount you have to make back is small, there's still very, very little deterrence to this sort of a schema. So you might have a theory where you believe in deterrence, and so you're just putting in place penalties in order to deter the crime. Nozick sees some problems with this. He doesn't think it's clear, and I don't think it's clear either, how much additional harm would be good to inflict in order to deter the crime. How much crime are you trying to deter? Are you trying to deter every single instance of the crime? Because if so, the penalties in addition to the restitution would have to be absolutely enormous. In addition to, are you trying to deter how much exactly? He says, okay, you might have a utilitarian come in and say, well, the way you decide how much additional penalty to put in place in order to deter the crime is you look at how much the additional penalty would inflict unhappiness on the punished people. So the people who were caught and punished with this heavier penalty, how much that hurt them versus how much pain did it save on the part of the people who didn't have the crime done to them. Nozick's issue with this is twofold. One, this might be way below what the retributists would say. It might be well below that retributist cap of just exactly the same amount of harm done to the criminal as to the victim. And so it might not be a very good deterrent, because it might just be that more unhappiness is done to the criminals who are caught and have to undergo the punishment, just because of maybe the sort of people they are. They're more prone to discomfort or unhappiness. And one of the major problems with utilitarianism is this sort of, what about people with like different scales, sort of a thing. Anyway, let's not get into that now. So you run, and you also run into the problem with, now you are weighing the happiness of the criminal on an equal standing with the happiness of the victim, which just seems wrong. It seems that the person who was wronged and had wrong done to them, their well-being should count for more than the well-being and happiness of the victim in the eyes of the court or legal system. So Nozick says, the utilitarian system is a bit strange, as like a thing to put on deterrence. So in the end, major theme throughout Anarchy, State, and Utopia is he just kind of gives what he thinks is reasonable and says, well, it's probably one of these three things, but he doesn't pick one. He thinks that this argument, the deterrence argument, is a good argument for not just requiring plain restitution and having something beyond plain restitution. And he comes closest to being a retributist, I think, where he wants the criminal to be inflicted with up to a maximum of however much harm they did to the victim as a way of deterring crime, but not just to deter crime because he thinks it's probably just because they inflicted this amount of harm. It makes sense for it to be inflicted back on them in some degree, but he doesn't take a firm stance. He would be okay with you here going with, well, we shouldn't go all the way up to the amount of harm they did. We should only go up to something less than that, because that's a good enough deterrent. We don't need to go all the way there, or something like that. He's okay with different legal theories here. He just thinks you should go beyond plain restitution. He also has a bit that I think is very interesting and very helpful, that I think could count as another argument for going beyond simply restitution. That's talking about self-defense. He says when you're defending yourself, you're usually allowed to do more to the criminal who's coming at you than you would have a reasonable fear of them doing to you. So let's say a criminal announces that they're going to break into your home and steal that $700 vase that I keep mentioning. Are you allowed to kill them in order to stop them from doing that if you have no reason to believe your life is in danger? Probably not. Probably not allowed to kill the person. That just wouldn't be proportional. However, you probably are allowed to do something to stop them that would cost them more than $700. So if they break into your house and you get into a scuffle and you break their arm and that costs them $1,200 in legal fees, no one's probably going to scoff at that. So you're allowed to do things to the criminal that go above the harm that they could have done to you. Not infinitely beyond it, but at least a little bit beyond it. And so it seems as though even if the criminal justice system can't go as far as you can in self-defense, like after the crime has been done, they have the $700 base already and they're away, maybe they can't go up to breaking their arm and costing them the medical cost of having to deal with that, but maybe they can go beyond just the $700. He doesn't actually use this as an argument for that. It's just kind of an aside where he's saying, he basically says you can draw against whatever the additional harm the legal system would have been justified in doing to the person, plus a little bit extra. So he says, whatever the extra harm the legal system could do, which is, in his opinion, so I've been just saying the harm that they've done to you, but he makes it a little bit more complicated than that. It's the harm they've done to you times some number that represents how responsible they are for the harm. So they could be not responsible for the harm at all, and it wouldn't be fair for them to make any retribution to you at all. So like, let's say something is stolen from you, and then a fence has it later. Someone who owns a pawn shop, maybe. Someone goes to a pawn shop and sells it to the pawn shop. The pawn shop owner is not at all responsible for the theft. He should be required by law to give you back the thing that is yours. It's not his now. but he's not liable for any of the retribution beyond that, because he's not responsible. Someone who's 100% responsible would be responsible strictly for double the damage they did to you. So instead of $700 they took from you, $1,400. Somebody who's somewhere in the middle, who's not entirely responsible but bears some responsibility, might be liable not up to the full 700 extra, but some smaller additional amount. Randomly, neither here nor there, getting back to self-defense. So Nozick says when you're defending yourself, you're definitely able to go up to that retribution amount, whatever it would be appropriate for the state to do above and beyond them simply making restitution to you. You'd definitely be able to go that far, plus a little bit extra. So they're trying to steal the $700 vase. If we are using the purely retributionist theory, where now they would owe you or would be liable for $1,400 afterwards, then in order to defend yourself, you'd be morally justified in doing some amount more, some function of the harm that you're risking above the $1,400. So, yeah, and that's also, I think, a good supporter for prohibiting at least certain things. Okay, that's his first argument, the sort of argument from deterrence. Second argument, what Nozick calls an argument from dividing the benefits of exchange. All right. I think this argument is absolutely brilliant, and it's the one Nozick spends the least amount of time on, which I think is a real crying shame, because in my opinion this is sort of the crowning one, like the best argument for why simple restitution, just giving back what was taken, isn't enough. So it turns out, if all you do is require someone give restitution for something they stole, you eliminate any incentive ever for anyone to engage in voluntary trades. Okay. And here's why. Let's imagine that somebody owns a vase. I keep using a vase example, but let's go with it. That's just what I'm going to keep using. Let's suppose that the minimum amount they'd be willing to give up the vase is $200. They'd take $200 for it, they'd feel better off. Let's say you're willing to give them up to $300. If you gave them $300 for the vase, you would feel like you are better off, just barely. You wouldn't be willing to pay $301, but you would be willing to pay $300. Now let's imagine you steal it. You just go up to them, you take the vase from them, knowing this information. When the courts come in, assuming they're good courts that are generally good at estimating this sort of thing, assuming you've already sold the vase, done whatever you were going to do with it, it's no longer in the picture, you're going to be required to give that person back $200. Because that's what simple restitution would be. Right? You're required under simple restitution to give back the person enough to make them slightly better off than if the crime had never happened. Right? Just to compensate them, to get them back up to, in the way Nozick would put it, up to the indifference curve that they were previously on. So, this system eliminates any incentive for you to voluntarily trade with someone. If you think that you would be able to bargain with them and get a deal that you'd both like, where you'd pay a certain amount and they'd give up the thing, you would literally never do that. You would just steal it, go to the courts, and then pay them the minimum amount that they would have accepted to be okay with it. So, it seems as though a good court system should not be allocating all of the extra benefit, and this is even assuming like there's a 100% chance of the person being caught. They shouldn't be allocating all of the benefits from trade to the rights violator, to the criminal who took the thing. Now, of course, this doesn't apply in a situation where the minimum the person is willing to accept is $200, but you're only willing to pay $100, right? Then if you steal it and you're caught and you end up having to pay $200, you're worse off. But in situations where a trade could have occurred, you are enormously incentivized just to violate the other person's rights and steal. There's never a situation where you'd have trade, which just destroys and wrecks everything. And I just think this is brilliant. Now, Nozick does anticipate a response where they would say, all right, well, we could just have, courts try to estimate what the price would have been that you two would have come to had you been haggling and make you pay that. But that runs into all sorts of calculation sorts of problems. That's not really feasible or possible to do. We can't really and don't really have theories of fair prices. And so, as a result, this gives us a good reason to prohibit crimes, to impose a cost on the criminal above and beyond what they would have done, just to make sure that we have a system where trade is legal and not something, or not legal versus illegal, but likely to happen at all. So you have another reason there to have sort of a retributionist theory where you have another reason there to prohibit, is the terminology Nozick would use, crimes ahead of time. So you say if you're going to commit this crime, you're not just liable for the damages you've done, but you're liable for stuff in addition to the damages you've done, probably, for using a retributionist theory, exactly double. So you steal the $200 vase that you were willing to give $300 for, going back to that retributionist theory, you would now be liable to pay $400 back to the person, thus incentivizing you to, negotiate with the person and get involved with the trade beforehand. Final argument Nozick gives, and I think this is his weakest argument, but it's the one he spends the most time on, is a sort of negative externality argument. He would probably call it the argument from fear or something like that. But it's an argument he gives for, again, why we should impose prohibitions, additional costs above and beyond simply requiring restitution. So he says, all right, let's imagine that when someone breaks your arm, $2,000 would be enough to make you say, okay, I'm happy that happened, right? Medical bills plus $2,000. So someone comes along, they break your arm, you go to court, judge says $2,000 for pain and suffering plus medical costs. And then you go away saying, I'm glad my arm was broke. I'm better off now. I got $2,000. Let's even say that you knew that ahead of time. You knew that if your arm was broke, $2,000 would be enough to make you say, yeah, I'm ahead. I'm better now than I would have been if my arm had not been broken, assuming I get that $2,000. Now let's say someone comes along in this legal system where $2,000 is just barely enough to compensate you, and you would be happy, and that's all that's required. And someone comes along and they says, all right, I may or may not break your arm sometime this month. Be on the lookout. Do you go around now hoping that your arm gets broken? Right, this was just barely enough to make you happy that it happened. And you know that once it happens, you'll be happy it happened, you'll be slightly ahead. Do you go around hoping that it does happen, or do you go around in fear thinking, shoot, this crazy criminal is going to come out and break my arm? Probably the latter, right? Well, Nozick says, imagine a society where you never require anything more than simple restitution, and everyone's walking around thinking, shoot, someone could come out and break my arm at any moment, and I'll just be better off, assuming there's no deterrence going on because there's no extra retributionary fees on top of it. All right, let's assume now that we're making them pay you for that extra fear that was caused if they break your arm. What about all the other people whose arm they never broke but still went around with that fear? That fear wasn't caused by them breaking your arm. That fear was caused by the fact that we never prohibit it or put in place additional penalties on top of mere restitution for breaking people's arms. Now, you could imagine someone who's insanely, ridiculously rich who says, I'm going to pay everyone in the world for the fear that's caused by me potentially breaking someone's arm. I mean, that could be possible, but that's a ridiculous amount of money that would cost to make everyone whole for that. And additionally, it wasn't really caused by them breaking your arm. It was the fear was caused by the fact that there wasn't a prohibition strong enough to deter people from breaking your arm. So it would seem a little bit weird to hold them entirely liable for all the fear caused to everyone, when the fear was caused by the fact that someone else could have done it too, and then would have been held liable for breaking the arm and the fear to the person whose arm they broke beforehand, and also potentially the fear of everybody in the entire world? What? That seems odd. We're going to hold them monetarily liable for all of that? So he thinks this sort of negative externality caused by the fact that you could have your rights violated and then only be barely compensated, and the fear beforehand of that is enough to justify having an additional retributive consequence on top of simple, pure restitution. Okay. Now we're going to start segueing into risk. Here's what you need to realize, though, about this previous part in Prohibition and why it's so important to our next upcoming talk, next little bit about risk. If it is okay to penalize people based on the harm that they caused in addition to simple restitution, this means that it's okay to punish people for simply attempting something that's going to violate someone's rights and harm them, and not just, but fails miserably. Someone comes to steal that $700 vase from you, they break into your house, but they don't break any windows or anything, they just jimmy the lock and they get in no problem, and they're caught. Maybe it causes you a little bit of emotional distress that they have to make up for you, a little bit of this, a little bit of that, but it's really no great penalty. If it's okay to prohibit them from stealing the vase, right, charge them the extra $700, the double, they would still be liable for that in this situation, even though they didn't actually steal the vase. They wouldn't have to pay $1,400, right? They wouldn't have to pay you to make up for the vase, and then an extra amount because of the harm they did and the rights they sacrificed and gave up by being willing to violate someone else's rights. They would only have to do the part for the willingness to violate someone else's rights and giving up their own rights in that particular way. But they'd still be liable for it even if their plan to violate your rights was a complete and total failure, or the attempt to violate your rights was a complete and total failure. So they come in, try to violate your rights, fail miserably, they can still be punished for it. And that's where it ties in with the issue of risk. So we're still left with the question, is there anything we should not prohibit? Right? Before I came into reading this, it was my sort of baseline that most things shouldn't be prohibited in the Nausicaan sense. That if you were caught and convicted of a crime, you should be forced to pay the overhead of the court system and the police that was necessary to capture you and bring you to justice, and for any damages done to the person who you wronged. And then, of course, it's unavoidable that you suffer the psychic sorts of damages that we talked about. But that you shouldn't be penalized beyond that. And Nozick convinced me that, at least in some cases, it does seem justifiable for a legal system to penalize you beyond that, probably up to that retributive limit. I didn't buy Rothbard's argument for retribution when I originally saw it. Certain theological sorts of arguments for that sort of legal system I did find persuasive since then, but not super persuasive. So Nozick here impressed me by convincing me that I was wrong, and that not only was simple restitution not enough, but that prohibiting some things made a lot of good sense. So this next part wasn't as important to me, because I already came from a baseline that most things shouldn't be prohibited, or most rights violations shouldn't be prohibited in the Nozickian sense, and that for most crimes you should just be paying simple restitution for the wrong you did. Nozick's justification for why certain things shouldn't be prohibited, and the only penalty for violating people's rights in some situations should be to make restitution for the rights violation, is to cover cases where transaction costs are very, very high for getting the benefit of the trade. So the two examples he uses are, imagine the person whose property you need to use for whatever benefit it is in a coma, and getting him to sign off on it may be possible, but it would take a long time, or it would take a lot of resources or a huge expenditure to do. Does it seem justified for you to just use what you need to use to gain whatever large benefit it is, under the assumption that when they wake up they would have agreed to it, and there is some sort of amount that you could have reached an agreement on? It seems somewhat reasonable that that would be okay to do, and that when he awakes, you can go through some sort of an arbitration process and try to arrive at whatever the market value would have been for the agreement. Or if someone is currently lost in the jungle and trapped on a jungle island using their property. I don't know why he didn't include a case like this, but the best example of a case like this to me seems to be a case where someone's life is in danger. So for example, imagine you're being chased through the woods by a bear, and you come across a plot of land with a no trespassing sign. Are you required to swerve and get killed by the bear? It doesn't seem to me like you're morally required to do that, although it may be the case that by going onto this person's property, you are infringing on their property right to not have someone on their property. However, are you infringing on their property right in such a way that you should be retributively punished and forced to pay back twice whatever the amount is that the courts determine the damages are? Like, let's say by running onto their property, you do actually damage some crops that you're running over or something. Even in this case, although I think that the right thing to do would for the person with the no trespassing sign to forgive whatever you may owe them, it does make sense to me that we would still have a court system that would say, oh, you damaged this person's crops, you owe this much in damages. It does not, on the other hand, make sense to me to have a court system that would say you owe him twice as much because you violated his rights, and in doing so gave up similar rights on your own side. It seems like there were extenuating circumstances in that case, and that the action should not be prohibited. So it does seem to me like in that sort of a case, or a Jean Valjean stealing a loaf of bread sort of a case, the right thing to do would be to require restitution under the law, but not to have a retributive framework that's designed to deter the action from taking place in the first place, or provide some sort of justice, because it doesn't seem to me like in the Jean Valjean or the bear situation that, I don't want to say that an injustice wasn't done, but it really doesn't seem to me like an injustice was done, even though a rights violation occurred, if that makes sense. Okay.